morning, everyone. My name is Tanya Richard, and I am acting commissioner and acting chief of the ALJ here at Oak. I'd like to call the meeting to order. Today is August 22nd, 2019. Let's get started. Is there a motion to adopt the minutes for the June 20th, 2019 meeting? And we did only just a little bit ago hand those out. So if you all want to have time to review.
Yeah, I didn't even notice.
And then I can come back to that toward the end of the meeting, okay? All right, so we'll move on to the next item. Number 2. We're going to introduce a presentation of the OKCP proposed repeal hazardous waste materials penalty schedule by Nicholas Dees.
Good morning. I'm Nicholas Dees, Assistant General Counsel at Oak. Today we're proposing a rule to repeal Oak's hazardous materials penalty schedule. This is being done because the Department of Environmental Protection will be promulgating its own hazardous materials penalty schedule, which will incorporate Oak's current hazardous materials violations. So going forward, it would be DEP rather than Oak that would be handling violations and penalties involving hazardous materials. Are there any questions? Okay.
Okay, is there a motion? Okay, and all in favor? And all opposed? Okay, thank you. All right, next. We have introduction of DEP's request for cease and desist orders by Mr. Kunis.
Yeah. Okay, good morning. Russell Kunis with DEP Legal. This month, DEP is requesting that the board issue, I believe it's 50 cease and desist orders involving failure to install backflow prevention devices. In each of these cases, the property owner has been ordered to install the required devices. They have been issued a summons for not complying with that order. The summons has been adjudicated in violation, and the property owner is still not in compliance with backflow prevention requirements. So in each of these cases, the department is requesting that the board issue an order to cease and desist.
Okay, are there any questions? Is there a motion to approve? Okay, and all those in favor of the motion? Okay, that's unanimous.
All right, thank you.
Thank you. All right, and next, the DEP's request for pre-sealing report by Kelly Corso.
Good morning, I'm Kelly Corso, Assistant Commissioner for Education and Various Division, and we have 17 pre-sealing reports for the board today. 2 of them involve noise code cases, and 15 of the reports involve backflow cases, including one that's a water shut-off recommendation. So I'll cover the noise code cases first, and then move on to the backflow cases. In one of the noise code cases, the respondent presented evidence of work that was done on the air conditioning equipment at the hearing to bring that equipment into compliance, and the hearing officer agrees with DEP's recommendation that the equipment remain unsealed, provided that the initial reinspection and further re-inspections for a period of 180 days show no violations. In the second noise code case, this one involved noise from the respondent Con Edison's gas generator. The respondent has provided evidence that it's disconnected its gas supply so that the generator is now inoperable. DEP has inspected the generator and confirmed that the generator has been completely decommissioned. And based on the decommissioning of the generator, the hearing officer agrees with DEP's recommendation that the C&D order be discontinued for that case. So those are the two noise code cases. The backflow cases, in 14 of them, the hearing officers recommended no sealing or other action based on the respondent's evidence of compliance presented at the hearings. In one of them, the hearing officer agreed with DEP's recommendation that the C&D proceeding be discontinued because the underlying summons has been dismissed. Now, the final backflow case, this is one in which the hearing officer is recommending the water be shut off. The respondent in this case is 5804-5808 New Utrecht Avenue LLC, and the premises is a restaurant and catering hall, and it's located at 5804 New Utrecht Avenue in Brooklyn. This case started back in 2013 when DEP issued the commissioner's order for the respondent to install a backflow prevention device at the premises. The order warned the respondent that if it failed to comply, that its water could be shut off. And in October of 2015 and May of 2017, DEP issued summonses to the respondent because it had failed to comply with the commissioner's order. The respondent failed to appear for either of the hearings, and default decisions were issued. On October 25, 2018, the board issued a cease and desist order to the respondent because the DEP record investigation that was done revealed the respondent still had not complied with the commissioner's order. The cease and desist order instructed the respondent to appear at a special hearing to show why the water should not be shut off to the premises. And this case has been adjourned 5 times between January 8th, 2019 and July 2nd, 2019 for the respondent to present evidence of compliance. And although respondent's representative presented a letter evidencing that they had hired a licensed plumber, they have not produced any evidence as to the status of filing the required plans for the installation of the backflow device. And the respondent's representative has been advised during the hearings that water will be shut off if they continue to ignore the order to comply. And at the last hearing, which was on July 2nd, 2019, respondent's representative offered no evidence of any progress toward achieving compliance and actually stated that the respondent does not use water from the line in question. DEP has recommended that the water service to the premises be terminated, and based on the history of the case and the respondent's continued failure to comply with the commissioner's order, the hearing officer recommends that the water to the premises be shut off.
Okay, thank you. Are there any questions?
I'm sorry, this is Elizabeth Bauer, citizen member. I don't have a question. I need to recuse myself from, or I think I should recuse myself from one of these matters, so.
Okay, so you want to
If we're
divide them up.
voting, if we're voting as,
Mhm.
on all of them at once, maybe we could just separate that one out. That's the Bill's Cherries one.
Okay.
Because a colleague of mine represented the complainant in that matter, so I just think to be on the safe side, I should recuse myself.
Okay, all right, so then, are there any questions as to the water shut-off case? Is there any reason for us to vote on that separately then from the others? There's no, okay, all right then, so then let's, is there a motion then to approve, well, you can just abstain, right? You can just vote to abstain on the, if.
Right, I'm just saying, if you were
Yeah.
voting on all of
Yeah.
them, I would have to abstain on
Okay.
all of them.
So as to the Dell's Cherries case, is that the type, what's the respondent's name?
That's correct, it's the cease and desist order number A 2016-0010.
Okay, great. So as to that case, is there a motion to approve? Okay, and how many are in favor of approving? Okay, and how many oppose? Any abstentions? Okay. As to the remaining, as to the two noise code cases, is there a motion to approve? And all in favor? Okay, unanimous. And as to the 14 backflow cases, motion to approve, all in favor? That's unanimous, okay. All right, anything else? Thank you. All right, so, is there a motion then to go into executive session?
Yes.
Back on the record?
We are.
Yeah,
Oh, okay.
let's go. We've been rolling.
Okay, so we're back on the record after review of the judicial report, which was presented by Timothy Jones, General Counsel's Office. And someone wanted to raise an issue regarding the item in the minutes from last meeting.
So, Shalonda Graham, Department of Buildings. My only question was, during our last meeting, when we did have the very long-winded discussion relating to the case where we couldn't come to a decision, where basically we didn't have enough votes, we did all agree that in the event there aren't enough votes, then the decision of the hearing officer would be the final decision. So I don't think there's any dispute to that, and I think we all agreed with that. But what we didn't come to agreement with is what we would send the respondent and what we would send the petitioner, including the language that it would be in. I think we were all in agreement that it couldn't be a decision in order because no decision had been made. In the minutes, it says that both parties were advised that the hearing officer couldn't make a final determination, which is fine.
That the board couldn't.
Yeah, that the hearing officer's decision was
Yeah.
a final determination because the board couldn't make a decision. But I just like to see the language. Now, granted, I have to be open and admit and transparent, I probably have a copy of this in my office because it's my agency. But as a general matter and as just being a board member, I really think that we should have seen the language first and agreed to it. And I'd like to see it now, without searching my office, on behalf.
Well, we can certainly send it to you, it's a letter.
Actually, can we see it
It's
now?
administrative.
Yeah,
I
I
don't
Can we see
have
it?
it.
Well, we can get it, right? Somebody's got a computer.
I
Let's-
don't,
Let's look at it now.
I don't have it, I'm happy to provide it to
I'm
you.
free right after this meeting too. We should really look at it now, but look, this goes a little deeper. First of all, it was a very contentious discussion. Tom Spetner, citizen member, by the way, a very contentious discussion at the last hearing about this case. And
There were very deep disagreements about the substance of the
excuse me,
case.
that's not the issue though, but it was a lengthy discussion. It generated some very spirited debate because there was a lot going on here about whether we defer to the hearing officer, how we adduce evidence against somebody who, we made a decision without a great factual link. So this footnote from these meeting, from last meeting, I mean, I just saw this today. First of all, can we get the minutes for each meeting 1 week prior to the board meeting? Can we commit to that?
Well, here's what I commit. I can commit to the fact that providing them this morning was late. That was not intentional.
Okay, but like 4/5 of this document for 4 or 5 years that I've been reading it is cut and paste tables of decisions. There's very few moving parts to this document. Okay, so it should probably be done, it used to be done a week or so after. Jim Macon used to turn around fast. But can we just get it a week before the meeting? Give somebody 2 to 4 weeks to get it done.
I said what I'm gonna say.
Okay, I
This
think
was
that's probably.
This was late, and it shouldn't have been.
Okay, but even if it had been done yesterday, which I would still argue is late, there's really some serious problems with what is written here. Because it
What is the
says,
serious problem?
well, it says after the meeting was determined that 180 days had expired.
That's when we learned, that's when we counted the days, yeah. We realized that 180 days had passed before our meeting. But the substance of the 180-day standard had already been discussed.
Right, but we got the count wrong?
No, we didn't give you a count.
It
We
said
didn't know how
after the
many
meeting
days
it was
it-
determined that it was wrong,
No, no, no,
that it
no, no.
expired.
But the 180 days had happened a few days before the meeting. We had not counted at the time of the meeting because we had not decided as a matter of policy that we were going to use the 180 days. as the standard.
Since this, let's just recast it this way. This is kind of an interesting postscript to our discussion because it really is outcome determinative, right? We had discussed promulgating the decision, 5-4, to hold the respondent liable, right? And
Well, right, at the prior
and-
meeting, that was the final vote. And then we subsequently realized we could not take action on 5 votes.
right, so I've been sitting around wondering about what's, thinking this was a dead letter, and I find out this morning that it's actually not, that it went in favor of the minority, right?
It did not go in the favor of any, it went to the hearing officer, whatever that
Right.
decision was.
Right, exactly, that's my point. I don't know, this
The
is.
hearing officer decision was actually in the direction of where you wanted
That's what I
the
mean,
decision
so
to go.
so in other words, I walked out of that vote a loser thinking last month, while
You
losing
walked
it.
out of, well, no, actually, the hearing officer decision always went in the direction that you wanted it to go. So you walked out as a winner based on our conversation that it was gonna go back to the hearing officer.
I think
decision.
you, in
I'm crossed up
April, okay, there were 2 meetings where this
Oh,
was
that's right.
discussed.
I'm
So in
conflating 2
April,
meetings.
in April, before the time had passed, we voted on it. And then that was the 5-4 vote. You walked out of that meeting thinking that there would be a reversal. It turned out that on reflection, that wasn't possible because it hadn't been a sufficient number of votes in favor of reversing.
Right.
So then, when we met again, I don't know if it would have made a difference if we had known the 180 days had already passed, would we have had any further discussion about it?
Well, then it would have
We
been
would have just-
dismissed, right?
I mean, ultimately, I don't think, it doesn't matter, because ultimately, the same result pertaining, because we didn't vote again with a sufficient number to,
We were
one
still
way or
stuck.
the other,
We
we
were
were
stuck
still
in the
stuck.
exact same place.
so it ended up being, whether we had known that or not, it ended up being the same result. If we had spent another hour and a half discussing it and then voted again and there was a 7-person vote on one side, then,
Look,
It wouldn't have mattered though. If we had done that, it wouldn't have
well, then
mattered
we
because
would have
the
left
180
thinking
days-
one thing and then would have found out later on
can we
that
just
our-
communicate better? That's the
efforts
point
would
I'm
have
trying
been
to make here.
futile.
That's the overarching takeaway comment. We need to communicate better. I mean, I had no idea you're the commissioner. That's
Was I
good
supposed to
news.
call you and tell you that?
I don't know, it's good news. Why not send out an email to all of us saying, hey, this is an officially
Well,
done
it
thing,
was noted- It was
congratulations.
noted in the paper, but I
The
didn't.
paper, meaning the New York Times or something? I don't know.
Well, I don't think they're that interested.
Well, I'm really interested in, to push
Yeah.
out a
I'd
note
love
to the
them to
whole
be.
board, to say, hey, this just happened is a really good idea. It's,
Believe me, there's a
I
lot.
believe you.
There's a lot that I've had to do.
I believe you, but just like, hey, this is an official act of, the office is a really
Yes.
good idea to I don't know, am I making sense? I'm not making sense.
Are you happy about it?
I'm glad it's complete, but I'm bewildered what.
Can I just put on the
Show it. I
record
mean-
to express my congratulations?
Yeah, I'm trying to, but wait a second, before we all start backslapping, why can't you just tell us?
I wish you wouldn't take it personal, Tom.
I'm not taking it personally, I just think
I have been busy.
we're really committed to really poor governance and
I
communicating
am
with
not,
your board.
I am not.
Oh,
You're
Shawna Graham
Who's
Department
committed?
of
Who's
Buildings, I
committed to
am not
poor
committed
governance?
to
Look,
poor
I've seen,
governance.
we have vacancies on the citizen side that have been open for a year or more. I think the
We've been
governance
working on
issues that I've raised are significant, and I really do think that a quick email saying, hey, important organizational development is a great first step at healing some of those deficiencies. That's
My
important.
understanding is that an email went out more internal, it was us that didn't, I found out, and I regret not having
I found out because of a taped up message on your nameplate. I found out because of a taped up message on your nameplate. I mean, that's not
We're very
That's not
busy.
impressive. I believe you that you're busy. I just think writing
Well,
an
yeah,
email
it was in the papers, and not for nothing, because of.
I sit on this board. I
Yeah.
shouldn't have to go read the
Because
Daily
of,
News for Oath News.
Some of the issues we have faced as a board, in Tom's defense of what he's saying, I get your point. But at the same time, because of all of those issues, I guess me personally, I was watching, waiting. I watched the papers. I put keywords alerts, so it's like, I don't think that's a big deal,
Right.
and I don't wanna lose sight of the point. Because my bigger point is the last meeting, when we left, we agreed to certain points, but where we did not agree is how we would communicate, going back to your point, that message to both the respondent and the petitioner. So I don't want us to lose sight of that, and, you know, my only point is, okay, well, let's see, because this language and whatever we send needs to be what we send every time we run into this, and given the makeup of the board, like I said to you before, I believe we are going to see this again. And since we're going to see it again, the board should not only know what these notifications or advisements say, we should actually, as far as I'm concerned, vote on it and say on the record, yes, we agreed to this instrument.
So I will tell you that it never occurred to me that that was something that the board needed to vote on, because as with any administrative decision that the agency makes, it's drafted as an administrative decision. It was not a legal decision. It was an administrative communication that this is what we are doing, therefore the hearing officer decision stays. Now, I'm happy to send out the letter to you, but that's why I otherwise we would have waited to the meeting. If I thought it was a decision that the board drafts, so that was the decision there. I mean, that was the thought process.
So Tanya, your point is that the letter that went out clearly came from Oath as the administrative agency, and
As a tribunal.
it was not
Right.
representing itself as a communication from the board. It just
Correct.
reflected what had gone
Correct.
on in the board.
In the same way that you have decisions in the motions to vacate, right? Those are not, necessarily, long hearing officer decisions. Those are, denied, that kind of a thing.
But given.
But this did provide an explanation, because I wanted people to understand, in the same way that the minutes talked about, the section of law that we were relating to. I wanted the parties also to understand, how we had come to that decision, what law we used to decide, even though the law wasn't, the rule that we cited wasn't exactly on point, but that was our guiding force.
Could I make just a suggestion that since Shamanda has raised an interest in seeing the language, that it be shared with us, and then that we could have on the agenda for next meeting just a possibility of a discussion if any of the board members have concerns about the language, so that perhaps it could be modified if it does occur again to reflect those concerns. So I'm just suggesting an agenda item, nothing more than that for the next.
I don't have a problem with putting it on the agenda.
You know what I mean? If you send it out, it might just be, oh, okay, now we know what it looks like, what it says.
This particular letter has gone out, correct?
Yes.
Okay, so why don't we just say that we'll get a copy of it to review before the October meeting, and if anybody has any questions or concerns, they can raise them in
Right,
October.
that's exactly what I was suggesting.
And also, to your point, I think it is, I consider myself a board member, not just when I'm here, but when I'm, all the time, I'm an appointed board member of this board, so it'd be nice to be apprised of new developments, whether it be a change in leadership or appointment of new members ahead of the
It's a fair
meetings.
point. It's a fair point.
Right, because it, especially over the summer, it's easy to miss things in the newspaper.
Anything else?
Yes, how are we doing on the appointments for the 3 building members?
We are moving forward. We're close to one appointment, an individual who will be before the city council next month, and that's the final end of the process. There are 2 others who are still going through an earlier part of the process. So we're getting there. Any other questions? All right, is there a motion to adjourn? Okay.
Oh, I'm
Yes,
sorry,
we don't.
Tanya, I don't think think we voted on, we discussed the minutes, but I don't think.
Well, that's
we
right,
voted
let's
on
go back
it.
to the minutes, that's right.
Can we
Did
talk-
you want to have any additional time to read?
Yeah, can we look at these minutes when we get the next set of minutes, and do them all together? Because I don't want to
Okay.
just skim them in a meeting and then, I want to read them. you know?
I don't think there's a problem, is there?
Well, the problem is I haven't read them, you know, so.
No, I mean, it's a minutes issue.
Yeah, I mean-
Yeah, we can.
Okay, all right, that's fine. We'll-
So can we
we'll-
circulate
so
them
we'll-
together?
We'll hold it then for the next meeting.
We should circulate them together if we could.
Well-
That way they're just minutes all together.
Well, we're gonna send these out along with a copy of the letter.
You guys realize that
That'll be-
the
that'll be
meeting
soon.
minutes are published online. On Google, you can Google the meeting minutes, well before the meeting.
The minutes that haven't been
These,
approved?
these were unapproved minutes are available online?
I don't know whether they're approved or not, but you can Google the minutes. That's fine.
Right,
Well, if
after we
well-
vote on them.
Okay.
Okay, unapproved minutes shouldn't be anywhere. Right, okay.
Okay. All right, so then, is there a motion to adjourn? All right.
Oh, yes.
Oh, they did.
Oh,